Good afternoon, everyone. I am Tasneem Fatma, the Managing Head of Socio-Legal Literary. I welcome all of you to the second edition of Shamnad Basheer Memorial Lecture, organized by Socio-Legal Literary. We are a student-run collective that works at the intersection of law and sociology. While the group has been a student-led initiative, it has received support from a range of noted luminaries, profound literati, dedicated law and policy students in its endeavors. Among other things, we aim at bringing access to constitutional law and policy scholarship in Hindi, Bengali, Tamil, Telugu, Punjabi, and other regional languages for a wider audience. We aim at bridging the gap of language barriers and creating a wider community for dialogues on issues that affect all of us. The Shamnad Basheer Memorial Lecture is an annual event in the beloved memory of Professor Shamnad Basheer, who was a pioneer in bringing inclusivity in legal education. He founded the IDIA in 2010 when he was teaching in the West Bengal National University of Judicial Sciences, Kolkata. He was a social justice warrior. He was not just the force behind increasing diversity by increasing access to legal education, or IDIA as we know it, but also access to legal education for Muslims in India, ILM India. In order to remember and commemorate the legacy of Professor Shamnad Basheer, we have organized this lecture. The lecture for this year will be conducted by Mr. Talha Rahman. Mr. Talha Rahman obtained his law degree from the Nalsar University of Law in 2008. He is the recipient of Vice Chancellor's Special Medal for Proven Leadership Abilities and Shell-Chevening Scholarship, through which he pursued his BCL at Oxford University. Mr. Rahman is presently an eminent advocate on record of the Honorable Supreme Court of India. He is also the force behind the foundation of ILM India. ILM has been formed as a platform to increase representation of Muslims in Indian law schools by conducting awareness campaigns in schools, enabling access to coaching, and supporting personal mentorship. We are delighted to have him deliver a lecture on the topic of inclusivity in legal education and the way ahead. I invite Sir to please take the floor.
Thank you, sir. So today's lecture on inclusivity in legal education and the way ahead. I think it's important to begin by remembering who Shamnad was. He left us at an early age of 43, but in his life, he's left an indelible mark on many lives. He begins by, contributing to the IP scholarship. But that aside, he's impacted so many lives by bringing people from the rural area, from the regional areas, from people not speaking the mainstream languages, and he brought them to the law school. He made them visible. He made their voices heard. The seeds that he planted will reap great fruits in the time to come. But it's important to carry forward the flame that he's lit, and something that I'm doing in my limited capacity, and all of you should also do. And it's something that social legal literary is also taking forward by organizing lectures such as these. There is some noise. Thank you. Okay,
Ghulam Ahmed Raza, could you please mute yourself? Thank you. I'm so sorry, sir. Please continue.
Sorry, it seems there was a disruption. Am I audible now? Am I visible?
Yes, sir. Yes.
Yes. Yes. I'm sorry, there was a disruption. I don't know why. So I was talking about Shamnad and the contribution that he's made the cause of inclusion. And that is that, I mean, apart from his contribution to intellectual property, apart from his contribution from setting up the Spicy IP blog, from intervention in the Novartis case, from representing the voice of the students in the Delhi University photocopying case, from challenging the virus of intellectual property appellate board. These are all causes that he has espoused. But more importantly, and I think very close to the heart of the students, is the issue of inclusive education on which he worked. I think as the time passes, we will all see the impact, because, like I was saying, he's planted these seeds, which will take some time, which will take some nurturing by the senior beneficiaries of the IDIA, from the people in the profession, from the people in the bench, and people interested in increasing access to education generally. And when that happens, we will see a large number of people benefiting from his endeavors, and also multiplying and passing on the benefits that they have uh, received from Shamnad's efforts to others who would be in the same shoes as those students who have benefited from Shamnad's philosophy. Now, coming to the main topic that has been selected by the socio-legal literary, which is inclusivity in legal education and the way ahead. Most of you may be familiar with the research that IDIA has done by coming out with a report. And it actually, in 2018-19 report, it found that more than 85% of the students who made it to the prestigious national law universities were Hindus, and many of them belonged to Brahmin community, which was the dominant Hindu caste. On the other hand, less than 4% of the students were Muslims, who constitute 14% of India's population. And experience would show that even within this 4%, a large number of students are actually those who could be arguably be the creamy layer of the Muslim community. And this is true possibly also for the other minorities and not just Muslims. And when I talk about minorities, I am not confining myself to religious minorities, but I am also talking about all kinds of minorities. The other issue of inclusivity is about having a regional diversity, or the lack of regional diversity in law school. And a majority of students who get selected in NLUs are students who hail from Hindi-speaking belt, and particularly from the northern India, which is Uttar Pradesh, Rajasthan, Delhi, Chandigarh. And this could be contrasted with abysmally low representation from the Northeast India, where states like Arunachal Pradesh, Mizoram, Nagaland, and Sikkim are not represented at all. There was very low representation from Himachal Pradesh, and in fact, going back to my law school days, one could actually count on fingers how many people were there from Himachal Pradesh. There is a certain degree of dominance that happens on account of the presence of regional groups within college, because what happens is that the function of bringing in diverse perspective from geographical boundaries of the country then doesn't happen. We'll come to this a little later. The conflict-prone areas where there's such a state of Jammu Kashmir, the northeastern borders of the country, the problems of those areas never really reached the mainstream, because again, the student participation from those areas is low, and it's low because of certain factors. Then the third aspect of that requires attention is the urban and rural divide. The survey revealed that most of the students hail from the urban and privileged background, and most of the students had already had the benefit of studying in English medium schools, which meant that they were pretty good at English language, and they could in turn maintain the system which was designed for them. Above all was the disparity that arose on account of prohibitive fees and the lack of scholarships available for such students. There are other systemic factors to which we will advert to shortly. But the question that arises for us is, what is the meaning of inclusive education? When we say inclusive, what exactly is meant by the term inclusive? Who are we trying to include? First, it means to have all children in the same school and classrooms. It doesn't mean that you will have separate classroom for certain set of students and certain classroom for different set of students. It means same classroom, same school, same facilities, or same privileges as the rest of the students or the target group. Second, the definition goes a step further to mean that real learning opportunities for children who have traditionally been excluded. The ambit of inclusivity in education as a whole, however, is much broader. It not only deals with receiving education, but also its component, including what is the education about and how is it to be imparted. I'm repeating it. What is the education about and how is it imparted? So it's not only that I am teaching X, Y, Z syllabus, but that how that syllabus is conveyed to you, that's also a measure that is designed within the definition of inclusive education. Therefore, education should ideally be holistic, acknowledging the various histories, identities, and lived experiences of people adjusted to current times. Inclusion is about inviting or creating an environment. It is where you invite people of different backgrounds to come and enjoy a lived experience of learning. It is about bringing different gender, different experiences, different backgrounds, different upbringings together in one place for everybody to relish and enjoy and learn from each other. So when we talk about learning that happens in classroom, it's not the learning that's happens vertically between the teacher and student, but also learning that happens horizontally between students inter se. And therefore, it's very important to have diversity. So when we are talking about diversity, we will be in the course of this lecture looking at the importance of diversity in classroom setting, diversity in the legal profession, and eventually diversity on the bench. That is diversity within the judicial side. Shamnad has worked a great deal to bring people into the legal profession by enabling them to join the legal education. So legal education is the first step, because those who graduate from the legal education will then join the profession, and some from the profession will join the bench. So the vision of Shamnad to get people to participate, to learn in legal discourses and bring their lived experiences is something that's going to travel from their law college life to the legal profession and then move on to the bench. It is something that will take some time, but I'm confident that we will be able to see certain differences and experiences those differences within the next decade, because there's been substantial time already when he set it up. So the first point of today's lecture is diversity in classroom. Now, how does it benefit to have diversity in the classroom? Number one, on any point of discussion, it brings diverse viewpoints. So when we are talking about studying in law school, it is not only about a certain legal provision that is told to you, or that is, these days displayed on a PowerPoint slide, or it's there in the bare that you read. It's about why that provision came about, what was the necessity of that provision, how is that provision to be interpreted, how is that provision actually being interpreted by the courts, and all of this requires a diverse viewpoint to be brought about. For example, if you look at the provisions pertaining to dowry, some of the students in a classroom may have had first-hand experiences of witnessing cases of harassment on account of dowry. Those are the experiences that travel to the classroom and then can be the basis for taking a discussion of the classroom forward, because many of the students may not have seen the same kind of depravity in the society. And one therefore learns from others' experience. The same could be true for special legislation dealing with child sexual offenses or SC/ST Atrocities Act. Within the Indian Penal Act, for example, one would see that Succession Act, you would see, how people are fighting about property. Like I say again, people will have different experiences. It's very important to bring those experiences to classroom. Then is the point of situational awareness, that you are cognizant of what is happening around you in the society. So, for example, a student from Madhya Pradesh who's studying in Chennai. Now, he will bring the set of experiences, the set of problems from Madhya Pradesh to Chennai. And he will understand from what's happening in Chennai as well. Then about personal life experiences. A bank loan, for instance, some of the students themselves may not be school fees or college fees up front, and they would have had to take some education loan. The recovery of debt procedure prescribed under the SARFAESI or the debt recovery regulation is something that they may be able to relate to in the first hand. In fact, when I came to Delhi in 2013, one of the first cases that I did in Delhi was the case of a student who had borrowed some loan and he defaulted in payment, and as a consequence of which he was summoned by a court. So, I mean, his experience of going to a court to deal with a situation where he had to borrow loan for his education and he didn't get a job after that, and that experience, that's the experience that can shape policy, that can shape the interpretation of the law, that can, for example, classification of non-performing assets. These are all experiences. Now, these are all legal problems, hardcore legal problems, that what is a debt, how should the debt be recoverable, when do you involve a court process, when do you involve a magistrate, how the magistrate should involve, should the magistrate give you a notice before going ahead with certain aspects, or when should the asset be classified as a non-performing asset and your credit rating should be downgraded by the bank. These are all legal issues affecting rights of people, but because these are all issues affecting the rights of people, it's important to understand how they operate. So when you get students from different background in a classroom, the discussion is live. They bring their own experiences of their family members, of their extended family members, and that's how we get to learn. And those are the points that remain with you for your life, because you will think that, look, back in college, this is something that somebody had told me, and this is something that works, that doesn't work. And this is really important. A college that does not have a diverse set of students would not be able to give you a quality education. This is very important, and I'm making a very important point. A college that lacks diversity would not be able to give you quality education, because it will then give you a pointed question, a pointed answer. Somebody is telling you what the answer is, but there is nobody to question it. It is, imagine cross opinions on a subject to be a sieve. In order to filter out things, in order to filter out impurities, you will need that sieve to operate. Unless that sieve exists, you will not be able to distill the correct, correct is a strong word, but you will not be able to apply the applicable, the most relevant interpretation, the most relevant approach that should be taken. Because the whole attempt of lawmakers is to make law open and shut. In black letter they will write X, Y, and Z. But when it comes to applying, when it comes to reading, when it comes to implementing it, that's the time when you have law books filled with interpretations and how should a particular clause be interpreted. Now, having made that very important point about presence of diversity in law school, I now come to discuss some of the barriers to diversity. And because we are talking about entry to the law school, CLAT then becomes the first point of discussion. It is a national level entrance exam held across India. It is arguably highly non-inclusive. The reason for that is that some of the questions in the test require you to have spatial engagement, which the report concludes, and it puts people with certain backgrounds in and certain abilities, special abilities, in a difficult position. The question paper itself is designed to maintain a grip over English language. So if you do not, for example, have an English language sufficient knowledge of English language, you may not be able to make the mark, and you may not be able to get through, which means that knowledge of English language is a very important tool that decides whether you're in or outside a law school. In my experience, I realized that people, for example, say from madrasa background or people who studied in the Hindi medium, find it really hard to get into good law schools because of the language barrier. Because the questions, not only the English, not only the portion of the question paper that deals with English language, but rest of the question paper also is in a language that they don't have very good command over. So there is a problem. So if you want to increase diversity, there will have to be some dilution there. Now, the question that will always be put to people who argue in favor of dilution of, say, English language skills in CLAT would be that you are actually diluting quality. But that may not be so, because once the student is inside the university, it's the job of the university to make sure that the student is up to speed. I mean, all of us have lived through schools where you don't just leave out a student who doesn't do well. You put an extra effort on them. So it's the responsibility of the university to also spend a little bit of extra time on such students. And I remember that in my law school, I was very fortunate to have English teacher in the second year, in the second semester, in the second year, who spent time recording every student, every student who wanted to be a part of that group, their presentation, and then she would make them listen to their own presentation. Then she would spend time with them identifying what they need to fix. This is a very important effort. I mean, it was a residential university. People could spare that kind of time. People had that kind of inclination. There were teachers who want to do that. And I mean, that's the kind of thing that Shamnad possibly would also want the universities to actually actively do. Therefore, the question paper of CLAT is designed not only to check the knowledge of English language, but proficiency. Take for example the location of examination centers. That itself could be a restraint against many of those people who are wanting to participate in the exam but don't have the means or wherewithal to come forward. The exam fees, the pattern of examination, there are many different aspects. There is so much scope within just one examination to fix that and make it more inclusive. But even if you are able to overcome these hurdles and you are able to get out and get into the law school, then there are certain barriers that may continue, which include just the problem of trying to fit in, trying to see what's going on in the university and trying to understand and relate to the people who are there. And that's the time when the university also needs to step up and do a kind of hand holding. A student may find it difficult to bear the financial strain, the social strain. They may not be able to afford a decent internship. They may not be able to secure an internship. So these are all factors that continue to persist because of an unequal starting point. And for that reason, specific compensatory efforts need to be taken so that the people or students who are at initial disadvantage do not continue to have the same kind of disadvantages once they are inside a law school. Now, within the law school system, many students allege that they have been subjected to discrimination. They have been subjected to insulting or disparaging remarks on the ground of their political beliefs, their religious beliefs, or their socioeconomic background. Uh, these are all factors that the university needs to deal with. These are all factors that the student bar council needs to deal with, uh, and there needs to be a systemic responses to it. Now, the second point that I need to deal with in my yes, I was muted for a while. The second point that we need to deal with in our lecture today is legal barriers or inclusivity issues in the legal profession. Now, in the long run, um, the systemic lack of inclusivity or lack of diversity impacts the legal access, impacts the access to justice, impacts the very foundation on which the Constitution is designed. The Constitution is designed on the premise that everybody is freely entitled to access justice system, and that's the reason why Article 32 of the Constitution has such an important place in the Constitution. Because it is designed on access, it is designed to ensure that everybody is able to get through to the courts and seek a redressal to their problem. And now, when the new generation of lawyer comes in, which has no experience of how others live, which has homogeneity, which has similarity of class, similarity of problems, similarity of biases, similarity of prejudices, similarity of the stories that they've heard, it's going to impact the standards of advocacy, and it's going to change how the justice would be meted out, how would it be delivered. Therefore, diversity in the legal profession is very critical for growth, not only of the legal profession, but of the advancement of the law. I mean, take for example, the arguments that have been made in the challenge to marital rape provisions in the IPC. A large part of argument that you see reported are actually manifestations or expressions of the lived experience of the women. I mean, I have used the phrase lived experience a number of times in my lecture, and that's because that is really important. What people live through, what people go through, what people have to face, their own experience of how the law operates is very important in understanding of the law and understanding of the Constitution, to understand how the equality actually should be reconstructed having regard to people's experiences. So the Indian Penal Code, which probably at the time did not take into account people of different sexual orientations, had a provision which applied very oppressively. It has an exception against women's autonomy, which continues today apply very oppressively. Now, unless the arguments of people who have faced the oppression, people who have suffered by the oppression of law, people whose voices have been silenced and muzzled because of the legal provisions, unless they speak out and say, look, this is how it is operating and that's why you need to strike it down, the legal profession doesn't grow. So the growth of legal profession is premised on diversity. on the brainstorming of ideas, on the filtration process of presenting to the judge the differing viewpoints and the benefit or the costs of taking a particular view in a matter. And this brings me to my third level, which is the diversity on the bench. Now, in 2005, Lady Hale, former president of the Supreme Court in UK, she spoke about diversity in the legal profession. And she quoted from Erica Rackley, and she said that once we accept that who the judge is matters, it matters who the judges are. Now, I'll say that again. Once we accept that who the judge is matters, then it matters who our judges are. Now, the outcome of several cases would be different if they were presided over or had different judges participating in the decision-making process. Any book on the judicial process would tell you that how the judges react, how the judges behave, how their own prejudices are, they are all determinative of the outcome of a case. And therefore, even, I mean, if you look at the US, for instance, in their jury trials, it's very important to pick the right jury because, you know, the outcome depends practically on that. But this, I mean, while this has been there for a while, the understanding that the judiciary also needs to be diverse is a relatively a new understanding, because we have so far, when it comes to judges appointment cases also, if you see them, we have focused on independence, incorruptibility, that is to say they should be beyond reproach, and quality. These are the three important aspects that we have been emphasizing for a long time when it comes to selection of judges. But little emphasis has been paid on diversity until recently. Now, I mean, now, for example, you have a judge of a different sexual orientation who's been recommended. You wouldn't see that several years ago because the need for diversity without compromising on the other three aspects was not felt so much. It was perceived that the judges would be able to take into account their own experiences, their own different experiences, and they'll be able to assimilate that. Because arguably, if the Supreme Court has to decide a question of law or a question of substantial question of a law, or that involves interpretation of the Constitution, that you do need judges who have certain experience. So if you have, for example, a judge coming from a background where he has a certain kind of experience, there will be an untold bias or untold experience that is likely to creep in the course of the argument. I mean, that's the uninvited elephant in the room that lawyers will then also need to deal with. Why do you need to have diversity on the bench? Well, the first reason is that the people should have that kind of connect that, you know, these are our judges, they are from amongst us. So some of the judges in the past have been criticized for being ivory tower judges who are very removed from day-to-day realities of the people. And that actually has been some criticism of the Supreme Court of India as well. Then the second is that, and connected to this is, once people feel that these are our judges who are deciding on our issues and they understand what our problems are, then it is then that the people begin to respect the Supreme Court. So the word honorable before the word Supreme Court is something that the Supreme Court has to consistently work hard towards earning. It's not something that you add I mean, it's not a phrase that you just added before the Supreme Court. There's a lot of hard work that goes before that honor is conferred by the people. It's one thing to, you know, write it like that. The other thing is for the Supreme Court also to earn that kind of respect from people. And then, of course, the third issue is fairness and equality. It's only when people believe that, for example, a farmer believes that his child could also be a judge in the Supreme Court, that the system is so fair that will allow him or her to reach that place, then he or she will start believing in the legitimacy of the Supreme Court. So it is very important to have judges themselves as expressions of fairness and expressions of quality of the Supreme Court, or of any judicial forum for that matter, for them to garner legitimacy. Then, of course, I mean, you have very talented people in this country, and there is no reason that why a certain kind of talent should be left behind on account of certain difficulties. So, I mean, it's only recently, about 20 years, 25 years ago, that we've started to pay attention to people who have special abilities and special needs to also be made judges of the lower courts compulsorily. Women, fixed number of seats reserved for them, to make sure that there is an issue of gender that is definitely brought in the course of the arguments, and it is there for them to address. Because if you have a victim of, say, sexual offense, and she feels more confident in having a woman judge, then there should be sufficient number of women judges to preside over, because that's the system of legitimacy that we are talking about. I mean, there is an element of emotional correct. Then, of course, and the more important is that if you have different kind of judges from different backgrounds, of different religious faiths, different belief systems, all working together to make sure that the law is decided correctly and in accordance with the values of the Constitution, then you do need judges who are bringing different perspectives on the table for discussion and for the identification of the most appropriate one that applies. Many works on the decision making process will show to you that the group decision making, which is inherent in our collegiate system of decision making at the higher courts, is contingent upon bringing diverse views, expression of dissent, and being able to agree and disagree and not get carried away. So unless the judges are independent, they are able to express their differences. They are able to voice the different views that they have. You will not have a correct decision making. So the correctness of decision making rests on these virtues that I just listed out. In the long run, this systemic lack of representation impacts the access to justice. I would very strongly urge that when we are looking at inclusivity in the legal profession and the way ahead, and the way ahead is extremely important, we have to start from every door that sort of guards the access to the next higher level. So if you're looking at law schools, you'll have to look at what's going on in the schools. If you're looking at legal profession, you'll have to look at what's going on in the law schools, what's happening in the state and central law universities. And if you're looking at the bench, you have to look at what is happening in the legal profession. How diverse is the legal profession? Because if you're not able to draw diversity, then you will have to take affirmative steps to make sure that the system is sufficiently diverse. And I think Shamnad's contribution in that sense is no less than of a prophet, and he holds a very high position in bringing about diversity in the law school, in the legal profession, and soon on the bench as well. Thank you.
Thank you so much, sir. The floor is now open for questions. You can either type those in the chat box or ask the question by raising the hand. I request the participants to show active participation by asking questions. Um, you can, okay, we have a question in the chat box, sir. Given that the law colleges operate on very small profit margins, how could they realistically address the issue of high fees?
Okay, that's a very good question because it seeks to balance out all sides. Well, number one, you see, one has to understand what the profit margin is, because it may be different for different universities. So university will have some for themselves to expend, and some for investment into infrastructure facilities, and some to expand. I mean, the way to address high fees could be figuring out ways of subsidizing students' education fees. I mean, it could be by bringing more projects, paid projects to the university, when getting students to work. It could be by persuading their own students who have graduated to set up more scholarship, because you see, if, I mean, the number of intake is only 100 and so many students have already graduated. It may not be entirely out of place to compel, well, compel is a strong word, but to convey and to persuade their own students to set up more and more scholarship funds, so that the fees is available to give to those students who find it hard to continue for the reason of financial distress. But of course, it will have to be, I mean, because number one, I don't know for sure how much is the profit margins of the universities, because it will vary from one to another. Two, it will have to be seen on a case-by-case basis, actually.
So there's one more question that we had received via email. The question is, we don't have Muslim reservations or other minority reservations. In the current scenario, the presentation is very dismal in the Indian law schools. So what's the way forward? Is reservation a way towards it?
Well, you see, so long as the number one, reservation is regulated by the Constitution. So you certainly can't have a reservation on the basis of religion, but you can have other factors, and that should answer one part of your question. I mean, and the second part on what are the steps. You see, if you actually see Prime Minister's 15-point program, and that's something that, you know, as Alim also tries to follow, that the objective of Prime Minister's 15-point program is to enable the community itself. So the prohibition is on reservation, but there is no prohibition in promoting activities like coaching centers, or, you know, skill development programs, or basic training programs, or crash courses, etc. So if the government is able to set up such skill-based or how should I say, not skill-based, but, you know, enabling measures, then those can respond to the problem to a great measure, unless we reach at a point where we are able to divorce the socio-economic criteria from religion altogether.
Okay, sir, thank you. There's a question in the chat box by Rashmi. In your opinion, what is the most challenging aspect of working in a diverse environment?
I think there are I mean, I would think that there are two. I mean, if the word most I can use for two of them, one is one has to be constantly conscious of their environment. That, you know, you have to understand that what is a given for you, it may be a huge challenge for somebody. I mean, it could be simply, you know, getting up and walking. People who suffer from particular diseases and who have problems in walking. It's a huge challenge for them and something which is a given for most of us. So one has to be constantly be aware of the differences in the environment. And the second most challenging aspect is to deal with it. So there is diversity. You have to learn. You have to appreciate what the difference is, what the diversity issue is, and then to incorporate that within your own within your own within your own working style, within your own method of working, and to build on it. I would think that this is really the huge challenge of working in a diverse environment.
Thank you so much, sir. We do not have any further questions, so I would like to conclude the session now. I express my gratitude to Talha sir for graciously joining us today and providing excellent coverage to the issue of lack of inclusion, particularly in the legal field. I would also like to thank everyone present here for being a wonderful audience. I'm grateful to the team at SLL for organizing this event. Thank you, everyone. Have a great day ahead.
Thank you.
Thank you, sir.